Negligence actions can sometimes set off a chain of events. So how far does liability go? In the 1968 Consolidated Petitions and Cases, known as Petitions of the Kinsman Transit Company, or Kinsman Transit Company No. 2, the courts chart a course for navigating these determinations. In January of 1959, a ship from the Kinsman Transit Company, called the S S MacGilvray Shiras, broke loose from her moorings and moved backside first down the S-shaped river she was on in Buffalo. The Shiras struck the S S Michael K. Tewksbury, and the Tewksbury broke loose from her moorings. The Tewksbury, followed by the Shiras, went downstream. Along the way, one of the ships struck the S S Merton E. Farr. The Farr was moored at a dock to unload a cargo shipment of corn, but broke loose from her moorings and got jammed near the dock. The Shiras and the Tewksbury kept moving until the Tewksbury crashed into a bridge. The bridge collapsed. The wreckage from the bridge and the two ships created a dam, which caused major flooding and an ice jam, spanning almost 3 miles upstream, including the dock where the Farr was. Transportation on the river was interrupted for about 2 months. Cargo Carriers Incorporated couldn't unload the corn on the Farr because the fireboat and harbor towing tugs needed to break the Farr from the ice jam were stuck downstream below the bridge. Cargo carriers had to rent special equipment to get the corn and fulfill their contract for it. The SS Donald B. Gillies was in a harbor below the bridge. Cargill Incorporated had a contract to deliver grain being stored on the Gillies, but to do this, the cargo on the Gillies needed to be unloaded on a grain elevator upstream above the wreckage. Cargill couldn't comply with their contract and had to get replacement wheat. This created massive litigation. Multiple injured parties sued Kinsman, the owner of the dock where the Shiras was moored, the Tewksbury owner, and the city of Buffalo. These cases were consolidated. The Tewksbury's owner was exonerated, but the others were found negligent and held jointly and severally liable. A commissioner was appointed to determine damages for each claimant. The commissioner allowed damages for the Gillies and the Farr to Cargill and Cargo Carriers, but the judge refused to confirm the awards. Cargill and Cargo Carriers appealed.